My lord, Advocate General is going to appear on behalf of the appellant university, my lord. So, my lord, the matter may come up after 2 weeks, my lord.
My lord, I am appearing on caveat, my lord. Can a date may be fixed, my lord? Because the petitioner was dismissed from service. Subsequently, it was set aside by the learned single judge.
Okay. Can it be on 11th, my lord?
No, that's the law.
No, 11th.
11th of
11th September.
September.
It will be too low. Can it be on 9th, my lord, if possible?
The Advocate General is appearing. Can we have it on 8th or 10th? These are Thursdays and Tuesdays.
My lord, 10th, my lord.
10th.
10th.
Or we may be allowed to make a mention on the date, my lord, for upgrading the method.
Item 35. Both sides are represented. Mr. P.J. Khokal, and counsel for the appellant submits that will be led by the Advocate General in the matter. And he prays for an adjournment. There is allowed. The matter stands adjourned today. Next, as agreed to by both sides, list the matter on 10 September 2026. The mention is for that.
May I please?
Oblige.
I beg to mention for listing of a matter as an unlisted matter today, because if this case was earlier mentioned and your lordship was pleased to allow my listing today, but since there are some defects, the matter could not be rectified. Defect could not be rectified in time. So this is a suggest purpose, I am obliged.
Please, your lordship. For listing of after read petition, lordship. Earlier it was left over, lordship. Can it be on Friday, lordship?
Give it to the court once they make some adjustments.
Obliged, lordship. Let me, lordship. Lordship, in item 11, I may be allowed to peruse the report, lordship.
It is lordship. Lordship, I beg to mention item number 34 minutes. I pay for the petitioner. We are required to file our rejoinder minutes. We are sent it for vetting minutes. So can it come up after 2 weeks minutes?
Okay. What is represented now? We have made by Mr. S. Vishwakarma and counsel for the petitioner. The matter stands adjourned today to enable the petitioner to file an affidavit in the matter. Just after 2 weeks is paid for.
I don't think
What is the matter about?
Well, this is a challenge against an award of the Human Rights Commission. There was recommended to be followed by the state government, but the state government did not follow it. So we have challenged it.
What will the High Court do?
Well, as per the Human Rights Commission Act, there is a provision in section 18B of that. We can
Okay. Okay.
Item number 13, we have filed an IA for amendment. That is not listed on it. So we will let it come on Thursday.
You want to call it now?
On Thursday, my lord.
Make it Wednesday. Item number
13.
13. What has happened in the meantime?
Meantime, nothing has happened. We have filed an amendment.
Okay. Item 13, both sides are represented. On the prayer made by counsel for the petitioner, that the affidavit filed by the petitioner be tagged with the record.
We filed an IA.
I
for amendment.
Okay, application. Counsel for the petitioner submits that an intro of the application has been filed. When they said IA be tagged with and listed on Wednesday. Okay.
Yes, may I please, Lordship? Lordship, in item 32, Lordship, I seek you, Lordship's permission to peruse the report, Lordship.
May I please, Your Lordship, I beg to mention for listing with the question for other.
Give it to the court master. He'll make adjustments. Give it to the court master.
May I please, Your Lordship? Lordship, mention item number 38, Lordship, admission matter. My senior is out of station. Time is past.
88.
38.
26 matter. Okay. Both sides are represented on the prayer made by counsel for the petitioner. This after
Next week.
this after a week. Okay.
Yes. May I please, Lord? Item number 20, my Lord.
Yes.
Matter of 17, my Lord.
may I pray for some more accommodation?
No,
Can it be?
2019 till 21 matters, please wait till we have the records. Then we'll consider.
Well,
That is lordship, my lord. Item 21. If possible, I have some personal difficulty in next
This
week.
is 2017 matter, you have to wait. 2017 till 21 matters, we are not adjourning at this stage. We'll look at the record and then.
Or motion item 1.
May it please, Your
Yes.
Well, this is an ex parte order, my lord. 5/12/2016 order, is it?
Where is the
Page,
page?
page 12.
Page number?
12. 1, 2. They failed to appear before the member tribunal. Notice was issued, my lord. They were not found, so it was hanged, my lord. In paragraph 9, I have stated that. Expert.
Radha,
Yes, lordship.
I think you'll have to do training programs for your the border police also. Give this.
Not as for the.
No, hang, but where it doesn't say.
Okay.
He went to the house, everything is stated, but where he hanged ultimately, it's not there. Follow the procedure. Back page is the report. Somebody will read it for her.
You want to submit it?
For third line, one whole.
So like it.
So Gusto Gauhati my. Gusto Gauhati my.
What was I saying to you? Notice to.
What is your explanation here? Why you did not appear?
Paragraph 9, my lord.
Paragraph?
We have not received the notice. Only after NRC in 2019 have informed us that such a order has been passed. Paragraph 9, lordship. Page 6. Latka jari kori. Then only we come to learn.
It is to yes, it is to
Ms. Verma,
Yes,
the
Lord.
stand of the petitioner is that the place where the address is, he is residing in the same address even now.
But here it says they were not found.
Maybe for a moment they were not
Yes.
there.
Lordship,
So send it back. to
yes,
the-
Lordship may send it back.
But Mrs. P. Verma, then counsel for the petitioner and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the party opinion dated 5/12/2016. Passed by page 12, passed by so and so and so and so, which the petitioner declared to be a, by which petitioner declared to be a farmer post 25 to 1971 stream. Next paragraph. The case of the petitioner is that he, along with his family, is residing in the place given in the address for since 1986. So accordingly, it is posited that the process server never visited the place of residence of the petitioner. And as the notice was served by hanging, the learned tribunal accepted the same as due service or notice and ex parte opinion was passed. Next paragraph. On a visit of the tribunal's record from which we call for, it is seen that the notice was issued to the petitioners at the address of village Nakhula, Nakhula-Grant, Nakhula Grant, Jagi Road, which is the address of the petitioners. And the cost title of this writ petition. And as per the process server, the petitioner was not found. Then the process server had gone to the place of residence and the notice was served by hanging in the presence of witnesses, which includes the Gambura of the Chagi Road revenue town. Next, the projection that the petition is available in the same address in which notice was issued and served. The projection that the petitioner is residing in the same address. Court is inclined to what is the considered opinion that a petitioner be provided with an opportunity to contest the proceedings. Joy Hari Vishwas. Joy Hari.
Name is Joyhari বিশ্বাস Lord.
Joy Hari. Joy Hari is against the person. My photo. Into wife and children saw now the knowledge. Yes. Getting one. Ms. Verma, basically it's not only for the purpose of this process service report. The defect in the proceeding is that the inquiry was only against Jai Hari Biswas,
Joyhari বিশ্বাস.
but
Opinion is against all.
against all of them, the reference was made against all of them. Sorry, the notice was issued against all of
All
them.
of them. So Lord,
Reference is against only one.
docket may indicate in the order that since the reference was only in the name of the petitioner, the others may be excluded. Lord.
In view of the fact that the inquiry was conducted only against one Jawahari Viswas. But and it also appears from the tribunal's record that the reference was also made only against the against Jawahari Viswas. But notice of the proceeding was issued on all the petitioners. Although there was no inquiry against the other members of the, against the respondent numbers petitioner numbers 2 to 6. Just according to the petitioner numbers 2 to 6 is permitted. So, no, don't say that, don't say that. Next, accordingly, the court is inclined to order as follows. Number one, that the impugned opinion dated so and so, page 12, is hereby set aside. And the matter is remanded to the learned member from a foreigners traveling first Morrigaon for a fresh adjudication, after giving an opportunity to the petitioners to contest the proceeding by filing written statement. Next, the petitioners, who are represented by their learned counsel, are directed to appear before the learned member from foreigners traveling first Morrigaon on or before 24 September 2026. On or before 24th September 2026, and on the same date, along with the certified copy of the order, also file the written statement of defense and the documents on which they intend to rely upon. Next, thereupon the learned tribunal shall provide sufficient opportunity, reasonable opportunity to the petitioners to provide their evidence on affidavit and to take steps for examination of other witnesses. Next, the learned tribunal shall make an effort to dispose of the proceedings in terms of para P within bracket 14 of the foreigners within bracket tribunal bracket was order count 1964. Next para. In the event the petitioners fail to appear before the said learned tribunal, within the time allowed, it will be open to the learned tribunal to pass such appropriate orders as the as may be permitted in accordance with law by treating the petitioners as defaulting in appearance in hearing to appear within the time allowed. Next one, parties are allowed to be given cost. Next one, the petition stands allowed to the extent as indicated above with order of remark.
Much obliged.
We just made the observation, you take the plea of no reference against others.
Much obliged.
Item 2.
Let's do the motion. So the challenge has been made, the opinion dated 15/5/2019. Rendered by London. Okay. Ms. Gauhati, since there's a lot of motions today,
Yes, Lordship.
we, all these matters where the old matters are there, we issue a notice and then list it in the admission column. To make an admission. Here you see both sides are represented. The record is called for is received, so accordingly the court is in, which requires examination, accordingly court is inclined to issue notice, returnable on so and so, list in the admission column on so and so. On admission time, we'll try to complete this. This will be like 3 weeks, 4 weeks. 3 weeks, 4 weeks. Just collect the date after some time.
Item 3.
This is also my lord, notice was not issued, my lord. Interim was granted and it also was called.
Which page is the opinion?
Page 72, my lord.
72. Both sides are represented. Pursuant to order passed earlier, the records of the tribunal is received, which requires examination. Next para. Accordingly, the court is inclined to issue notice, returnable on so and so, without requiring any steps to be taken. Next para. This is the matter on so and so in the admission column.
23rd of August. 23rd of September.
Hello, brother.
Just collect the date after some time. They'll be, what do you call, it will be preponed.
Item 4.
Here in this case, notice was not served, my lord. It was through hanging, my lord. Change of place is there, my lord. Case 9 is there. Welcome.
It has to go back. The notice was pasted in the market.
Lordship, when she shifted, she did not inform the authorities also.
That's correct, but not at the last address. You can send it to you, market last. Okay, okay. So Ghosh, please read it. That Jarikar report.
নতায়ন মতে আমি নোটিছত উল্লেখ থকা গাঁৱতক গৈ গণ্যমান্য ব্যক্তিক লগ ধৰি সোধপোছ কৰাত জনা যায় যে উল্লেখ থকা মানুহজনী হৃদয়তপুৰ গাঁৱত নাই। গতিকে দুইজন সাক্ষীৰ চহী লৈ নোটিছটো এটা কপি গিৰিধাৰী বজাৰত মানুহ দেখিছে আৰি দিয়া হ'ল আৰু এটা কপি মহামান্য আদালতত পঠাইছে।
Lordship, I have just one submission. This time it should be the last chance that they appear and complete the
Our
procedure.
orders are very clear.
Yes,
On
sir.
that day, they will appear with the written statement.
Chance and opportunity granted, Lordship.
No, that is inherent in normally in our orders. Last order also was the same thing.
So, madam, please to call back.
That was S.K. Ghosh, learned counsel, who has appeared on behalf of Ms. F. Ahmed, learned counsel for the petitioner on record, and also heard so and so for the respondents. Next one. Regarding this petition on Article 226 of the Constitution of India, the petitioner has assailed the ex parte opinion dated page 9, 2012-2017, passed by so and so and so and so, by which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Next part, the ex parte opinion is assailed on the ground that the notice was not served in accordance with the procedure prescribed under the Foreigners within bracket tribunals, bracket close order, 1964. Next paragraph. On a visit of the tribunal's records, which were called for, it has appeared that it is seen that the notice was served in the market area and was pasted in the market area and not at the last known address of the petitioner. As per the process service report, the petitioner was not found in the address and therefore notice was pasted in the market area. Next paragraph. The Lawrence Counsel for the border and FT matters has opposed the petition on the ground that when the petitioner changed her address, she did not disclose the same to the competent authorities. Next paragraph, be the resignate. The service of notice by pasting it in the marketplace. Is found to be not in accordance with with the provision of paragraph 3 within bracket 5 within bracket 5, small f of the foreigners within bracket travelers, bracket close order, 1964. Next, accordingly, the said ex parte opinion is not found sustainable. Accordingly, the ex parte opinion dated so hereby set aside. Next, the matter is remanded back to the learned member from foreigners tribunal number 5, Gwalpara, number 5th, Gwalpara, for a fresh opinion. Next, the petitioner, who is duly represented by her learned counsel, is directed to appear before the said learned tribunal on or before 24/9/2026, and along with the certified copy of the order, also file a written statement of defense and also submit all the relevant documents on which she intends to rely upon. Next paragraph. Thereafter, the learned tribunal shall give some time to the petitioner to file her evidence and to take steps for summoning witnesses, if required. The said learned tribunal shall make an attempt to dispose of the matter within the time prescribed under paragraph 3 within bracket 14 of the foreigners within bracket tribunals, bracket close order, 1964. Next paragraph. In the event the petitioner fails to appear and file a written statement of defense, it will be open to the learned tribunal to treat the petitioner is absent on call and or be pleased to ask such further or other orders as will be deemed fit and proper. Next, the petition stands allowed to the extent as indicated above with an order of demand. Next, the tribunal's record be sent back immediately.
Much.
Return back the records. What is given? Item 2. Now 1.
Item 5.
Now appears on call for the petitioner. How all the respondents are represented. Next, for the range of justice, the matter stands adjourned today. Next, it is made clear that if the petitioner remains absent on call on the next date of listening, adverse orders will follow. Okay, you're there. Yes.
Yeah, on last occasion, PCO was called for and the same has been received. The matter will be fixed for hearing.
So we are ready for hearing. This 2019 matter. You're not prepared.
Lordship, my senior is on
Always.
lax.
Always be in court with the brief, otherwise you'll you'll face these consequences. Okay, both sides are represented. In view of the order passed earlier, the records of the tribunal is received, which requires examination. Next paragraph. Accordingly, court is inclined to issue notice returnable on so and so without requiring any steps to be taken, based in the admission column on so and so.
Item 6,
May I plead, Your Lordship? Your Lordship will find the interim order at page 42.
Only that of us. Ms. Verma, the next week you go through Ms. Verma, you go through the record to make date.
Yes, no.
There is no link here.
Yes, no.
There is absence of any link. We don't find a link here.
I couldn't find it. I was also going through the.
But,
Next day we'll look at
but
it.
the problem with this record is that it is a clumsily maintained record. The exhibits are not in serial order. It's very difficult to find out exhibits. I don't know why the exhibits were broken up and rearranged it. 1 to 3 plus 12. Okay, both ways are represented. So, pursuant to order partially, the records of the tribunal is received, which requires examination. Accordingly, court is inclined to issue notice, letter number on so and so, without requiring any steps to be taken. Next is the admission column on so and so. In order is at page 42.
Item 7.
Yeah, please, Your Lordship. Lordship, this matter may kindly taken after some time. Lordship.
That's all.
Till 8 minutes. Eight, 9.
We'll take it up the latter part of the day. You just go through the records. Here, the problem is that in this case, the written statement only was filed without any evidence being led. So there is no evidence at all.
Item 7, Lordship. Yes.
Yes, what matter?
Yes, sir.
7.
All of you should vote.
Item 8.
Yes, please, Your Lordship.
Yes,
Lordship was called for a report on page 66. Annexure 18.
yes, you have to go through the record. In one of the opinion, you are declared to be not a foreigner. Just go through the records as well. The other records have come. We'll take it up after some time.
All of you.
Item 9.
It is 29. Repeat what you are saying. Because issue policy, remember what's the came to me. Yes, Baba, this, we are not finding it today. And now I'm missing it. Earlier, you would remember, we found out about the existence of a erstwhile tribunal, Spark Infiltration Tribunal, that was functioning before 1964 order came. Infiltration tribunals were there.
I found it in this.
We, we, we had found out earlier in one of the matters we decided earlier. Here we want you to see this. It-
But they have not been able to establish a link with this document also.
But the copies were issued by the Motor and Train Tribunal. Therefore, these records must be somewhere.
Yes, because the seal says MSCT seal is there. Yes, it's document. MSCT tribunal of the part of the it's a tribunal. In fact, this is the first time I'm coming up across this document.
No, we got it earlier also, but that time we could get there. This was under the Pakistan Infiltration Prevention Scheme. These tribunals did not have an existence as the legal framework, but it is under the prevention of Pakistan Infiltration Prevention Scheme. that was there under the Home Department. It is through that these tribunals were there, but these are not statutory tribunals under any act or rules. But these were not created under foreigners tribunals, and what happened here was that this order will say that it's a notice to quit India.
With India notice.
So on that, hearing were held, and these notices were either there or they were withdrawn. So in this case, it was withdrawn.
It was withdrawn, Lordship. But the name Sanu Sheikh is I'm not able to connect that with the petitioner.
No, that's okay. That's one part. But to have this, to look at this, because somehow these records were kept in the tribunal. Therefore, the tribunal got this and gave it, because it would use the current seal. And therefore, they would send it. That means the records exist. If there is a
Still exists somewhere.
you can have the Naga SP find out, and they will give you the briefing. This document is annexed to the writ petition also.
Petitioner. At page 83, no, not 83, Lordship, it is
Page 60.
5960, yes.
Yes. Because the tribunal has issued this in 66, it will not issue unless
This is a certified copy obtained in 66 only. just get the information, we'll put it in the order. There's no representation from the petitioner. All the respondents are represented. According to findings of justice, the matter stands adjourned today. Next paragraph. Next, on the next date of listing, the learned standards for the border and FT matters shall address the court on in respect of the tribunal, comma, part PAK, part dash infiltration, which is referred to in annexure I of the writ petition at page 60. Next paragraph. In view of the pursuant to order passed earlier, the records of the tribunal is received, comma, which requires examination. Accordingly, court is inclined to issue notice, return of allowance and so list in the next paragraph. It is made clear that if the petitioner remains unrepresented on the next date of listing, comma, adverse orders would follow. List also and so. Lordship, Lordship would like to look into the records of this tribunal, the Indo.
No, just we have said that you will address us on that.
Whether
It will enable you to
exists-
get instructions.
What instructions, Lordship?
No, existence of this, because the SP order will be able to tell you. And the instruction, second instruction is that how could the MSCT be giving that?
Issuing this.
You see, this 1966,
The custodian of the records. Basically, the custodian of the records.
because you see, it's tribunal in 1966 were functioning under the 1939 Motor Vehicles Act. So after that, what you call 88 Motor Vehicles Act, then now it is the new act. So whether they could trace out this, it can be tracked on, if the SP says that these tribunals were there, then this perhaps would be a good document. No, earlier I could, I was able to find out, but today, for some reason, the information is not available in the internet.
It is very slow, Lordship. Net is not working in fact. We'll get it.
The reason is different. The reason is that search, apart from the legal search, goes to somewhere else. And there are so many users at a time. So therefore, even our net works slow. Although we have a different different window for our connectivity, but still it is slow.
We'll get it. I'll send it across to the SP Lodge.
Item 10,
Matter may be taken at two, Lordship. My senior is appearing another court, Lordship.
Lordship, if notice has not been issued, Lordship, we issue notice.
no, we'll just see the order, then. You see page 34, that will give you an idea why, what has happened. Page 34,
Yes, Lordship,
first exhibit is voters list of 66, then 70, then 97,
that's it.
and then there is no connection.
Gaubura and voter identity.
Okay, after some time. After some time.
At two mile.
Item 11,
Yes, which page is the opinion?
94.
Which page is the exhibit 11?
Seventeen animals. Translated to then vernacular is 880.
Can hardly read anything.
That is the certificate copy and the Xerox special.
Please have it back. Please read and tell us the remark column regarding Sajida. Ithar Sior so and so Taikor Hukumote. Next, what is the next word?
অংশীদারি সূত্রে maybe অংশীদারি সূত্রে maybe
Pardon me?
অংশীদারি সূত্রে maybe
Onkidari Hutte. But this is not all. You are unable to read that. Onkidar is shareholder. Shareholder in what capacity? Onkidar in what capacity?
it may be
No. Onkidari Hutte 3 number so-and-so's logot.
Patagari supposedly wrong is father.
Hmm?
Pata number 3 is
So till your father is alive, you can't have that mutation. Because with a dead man, your name will never come. Halak is we understand. If somebody died, then you come in place of him. And that will be Uttaradhikari, not as Onkidar. Not a shareholder. I don't take my property of my father as a shareholder. I take it as his legal representative as inheritance. And this has got no relation with your exhibit 2.
exhibit 2 is another
Pata.
Patalashi 1962.
But that Pata has no link with this document.
This was separate.
Then there's no link.
So petitioner father in the year 1966 and 1971 total name liquidation.
You don't, you're not finding it. On the next date, Ms. Verma, on the admission day, you examine this records because this is you're not finding a link. If this snaps, then there is nothing to connect. How many witnesses were examined?
So petitioners and
Hmm?
2 witnesses lordship. And petitioner was not examined. His evidence was submitted, but
Petitioner was not examined.
lordship. And his brother was, some question was put by the learned tribunal. Evidence was submitted. Lordship. But no question was put by the learned member, and also there was no government leader lordship.
Okay.
Documents. 13 documents.
Footprint of. No. What is the name of your father?
Fazlur Rahman Gazi.
Yes, both sides are
Yes,
represented. Pursuant to order passed earlier, the records of the family is received, some of which requires examination. Accordingly, court is inclined to issue notice returnable on so without requiring any steps to be taken, as per list in the admission column on so.
Item 12 for motion.
This is Ali, which
May I please, Lord? My order dated, my lord, 12/5/2020, my lord. Issue was called for and interim was granted, my lord.
page 39. No. This is the page of your opinion.
Opinion, my lord, 45.
45.
45. My God. I'm taking this. This is a-
Only one difference. Two.
Two, my lord. One has not been discussed, my lord.
There appears to be no link here. 66 and 70. Which page is your written statement?
Written statement, my lord. 17.
Your school certificate gives your age of birth,
School certificate of father, my lord.
school certificate of father
Yes.
of 1946. Which page is that?
School certificate of page. It's 25, my lord. 25.
Forty-nine.
From the written statement on whether reference was get all the family members. Reference was, I think, all the. From the written statement, it seems like that, my lord. There is no discussion in the Indian opinion. I do not know about this one. Oh, this, I don't know if you see that, reference in the. But, oh, that's easy, you would have found it.
Father's name is Father's name, my lord. Prohibitions. Lordship. Information. Inquiry report. Yes, supplementary. In the inquiry report, father's name is available. Move. Okay.
There's no connectivity, no link established. Come on, both sides are represented. List in the admission column on so and so. Opinion is at page 45. Dated. You don't have to say that. Both sides are represented. Pursuant to order passed is records of the travel is received. It requires examination. You should notice list in the admission column on so and so. What did you did a copy? Okay. A copy of the representation you provided with knowledge chronicles for the more than 80 matters will issue working days. You had put a question regarding that reference. What was that? In what context?
I think it is a wrongly submitted, my lord. In the written statement, my lord, the written statement filed on behalf of other OP also. Prayer portion also. my lord. Is for a
Learned counsel. No, reference is only against one.
with
14th of September. Item 14.
Yes.
The contested case lawsuits, the impugned opinion lawsuit, the case 123 lawsuit. Wow.
This question. Was this matter remanded back to the tribunal? No. This is something your home will have to flag. This is a case of 2017. Opinion passed in 2025.
25 law.
And references of 98.
And it.
If this is an issue, you'll have to flag. They will have to create something by which they can monitor. It should not take 8 years for the opinion.
Records may reveal if the
No, it's not a question of this record. Then
there are many
there may-
lordships. 8-9 years is a normal thing in this. Yes,
I am ready case law.
in between shifting of the tribunals, the new tribunals came up. Then again, some files were not opened for many years, lordship.
just have this flagged. Heard Mr. N. Ahmed, learned counsel for the petitioner, and so for the respondents. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated page 123. I have given a tick mark. 24/9/2025, passed by so-and-so in case number so-and-so, corresponding to case number so-and-so, by which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Next paragraph. Issue notice returnable in 4 weeks. Next paragraph. Extra copies of the writ petition be provided to the learned CGC, State and Departmental Council within 2 working days. Next, the relevant records be requisitioned from the concerned tribunal. by issuing requisition to the to the following email address of the said learned tribunal. Next, the prayer for bail is opposed by the learned standing counsel for the border and FT matters. Next, considering the projection, 10 days time to take bail or rupees 5,000 to the satisfaction of Superintendent of Police Border, Borpeta. The conditions, you take it from my secretary. Next, para. List out of 4 weeks on receipt of the tribunal's records.
Within 15 days, within 15 days, yeah.
10 days?
10 days,
Item 15.
May I please, Your Lordship?
Opinion date cycle.
Your Lordship, kindly turn to page 103. This is the final opinion.
Okay. Okay, it will be same order which I passed earlier. But Mr. S. Alim, learned counsel for the petitioner and so and so for the respondents. Opinion is at page 103, dated 29/1/2026, passed by so and so in BFT case number so and so, IMDT case number so and so, by which the petitioner was declared to be a foreigner post 25 in 1971. Same order, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Kamrup at Amin Gaon. List after 4 weeks on receipt of tribunal's record.
Deeply.
Yes, item 16.
May I please, Lord? Kindly, page number, my lord, 107, gives you an opinion, my lord, page 107, my lord. It's a contested case, my lord.
Here also same order. Mr. S. Ahmed, learned counsel for the petitioner. Opinion is at page 107, dated 29/4/2026, passed by so and so in FT case number so and so, IMDT case number so and so, by which the petitioner was declared to be a foreigner post 25 in 1971. Same order, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Borpeta.
Better, my lord.
Okay. Same order.
Obliged, my lord, much obliged.
Item 17.
May I please note the order opinion we are challenging is at page number 96.
Ninety-nine.
96 Lordship. Page number 96. Order is of dated 22/4/26.
Okay. Name of the internal counsel is Mr. J. A. Sigdal, and counsel for the petitioner. Opinion is at page 96. Dated 22/4/2026. Passed by so and so. In case number so and so, police reference number so and so, by which the petitioner was declared to be a foreigner post 25/2071. Tomorrow, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Dhubri. List of performance of the city of Paramount records.
Supplementary item for motion. Item 46.
Yes,
Hey, please, my lord. Lord, it is a preventive detention under PIT and DPS Act, my lord. Was detained on 7/6/2026, my lord, pursuant to the order dated 30/10/2025.
where is the detention order?
My lord, I kindly have page number 49, my lord, 49.
Yes, Sharma, and the counsel for the petitioner, and also heard.
Is just for one and
That's done it's easy, appearing for respondent number 1
two.
and 2. And Mr. N. Upadhyay, additional senior government, P. Sharma, the additional senior government advocate representing respondent numbers
3, 4,
3 to 13.
3 to 13. One, the presentation also file manager. कोई लोग पता होगा नहीं क्या ना पाए तो कोई होगा डिस्कस करेंगे कई बार क्या मन में तो कोई होगा तो सब बना कर ले आएगा अभी तो शो के तो आगे नहीं कोई देगा representation or file binder before central government, page 54, he is already filed on repeated.
Recently filed. Yes, madam.
Once copies are received, we will get information. by filing this writ petition in Article 226 of the Constitution of India, the petitioner is who is currently under preventive detention, is seeking issuance of a writ of habeas corpus to sail the impugned detention order dated numbers so and so, page 49, numbers so and so, dated so and so. By which in exercise of power under the PIT and the PIT NDPS Act, or the petitioner was detained on being continuously indulging in illicit trade of narcotic drugs, even after his arrest on several occasions. So the representation submitted by the petitioner is annexed 3 to the petition. Next part. If you notice, returnable on, give a date after 10 days, returnable on so and so. Requisite extra copies of the writ petition. Both hard copy as well as this soft copy of the writ petition be provided to the learned CGC and the learned State Council in course of the day. So as to enable the respondent, them to obtain instructions and to file affidavit in opposition, if so advised. Next para. List on
My name may be
Hmm?
Is that maybe some, madam, not
Pardon me?
name. My name may be Swan.
Acha, no. Just before the last line, you say that the name of Mr. H. Das done at CGC be reflected in the cause list while listing the matter next.
28 August.
Oblige, my lords.
Upgraded item 43 for orders.
May I visual?
Mr. Sharma. Obviously, when counsel for the petitioner has left in that earlier item, I think on administrative side, we have to have a meeting with your authorities in the Home Department with regard to that PIT NDPS. Then ask them anybody to give a courtesy call after. After getting a time, they can give a courtesy call. There is a 10-minute conversation we have to have with the Home Department who deal with this NDPS Act. And also, well, that's all. We will deal with it. Yes, Ramtra, very.
May I please, your lordship may kindly pass off the matter for the timing. Mr. Dinath is on deck. Mr. My sir is
For
on
the
deck.
timing,
Yes,
what time?
for the timing.
For the timing will be, how much time? Half an hour, 20 minutes?
Lordship may kindly fix the matter to
Pursuant to last order, my lord, we have deposited the money. Lordship had directed us to deposit 25% of the demanded amount. We have deposited it. So
That
now
will be-
they have to respond to the writ appeal if they wish to, my lord. Otherwise, Lordship will fix it for hearing.
2 o'clock.
At what?
Upgraded item for orders 44.
May I please, your lordship? My lord, in this case, my lord, we are appearing as legal aid counsel, my lord. What we find, my lord, there are some, my lord, typographical mistakes.
Discuss.
My lord, there are some typographical mistakes, my lord, in the review application which need to be rectified, my lord.
Oh. That too after 11 years.
No, my lord, the case was filed. This review application was filed, my lord. January 2026. Just come through the.
Is there a, under the, since I'm not aware, I'm asking you, under the Mohammedan law is adoption permitted? Under which section of the Mullah's principles of Mohammedan law we'll find that adoption?
That of course, my lord, I need to, adoption, whether it is permissible, my lord. Yes. Yes, my lord, I'll have to, check, my lord, I'll come back, my lord.
No, because we don't find it in the Mohammedan principles of Mohammedan law. Principles of Mohammedan law, we don't find it. That's why we are saying that I'm not aware. Since it is not in the law books, we are not aware.
The fact remains, my lord, yes, he was adopted, whether,
Can't take that the.
yes, whether that is, permissible or not, my lord, I'll, to that aspect, my lord,
It is not legally principle, that cannot be a ground event for issuance of notice. Yes, this is, madam, this is your FT matter. He is filing this review application and the condonation application seeking a delay of more than 4,000 days. In filing the review application, the ground is that the petitioner has now found out that he has been adopted by someone as his, from his parents.
so he's trying to link himself.
He's trying to link himself and then he has got a, if you come to the main application at page 30, he now says that in the school certificate he found that name. Therefore, there is an adoption. There is no, we don't find anything to show that how adoption took place.
Then lordship, if he is not able to prove it himself, he'll have to look into the technical aspect also. When was that adoption done and the documents related to it, whether they are valid or not.
Oh,
And
that's another thing. That will
adoption
come.
Process.
No, that would come.
That will come later.
That would come later.
Yes.
Now under 4,000 days delay.
Yes,
whether it is permissible, my lord. For that, my lord, I need some, my lord,
It's not there in the
Oh,
act, it is not there.
Well,
For law, we don't need
I-
much assistance. 4161 days delay.
copy this, sir. Copy नहीं दिया तो फिर फाइल ना है।
নামও শো করা নাই, কপিও করা নাই।
Make a submission, give the name, it's not here. Principles of Mohammedan law, we got. It's there. I do. Just 2 or 3 series of questions. Number one, whether there's anything on record to show that your biological parents or your adoptive parents are alive. Is there anything on record that when this matter was heard in 2014, the writ petition was heard in 2014,
Correct.
or when this opinion of 19/9/2008 was passed, whether any of your biological parents or adoptive parents were alive? First is 19/9/2008. This is the date when opinion was passed.
Right.
Second date is 20 February 2014, when the writ petition was, the final order was passed.
Then, my lord, writ appeal.
No, it's okay. We are not in appeal. We are still in the writ petition.
Yes.
These are the 2 dates on which whether your any of the 2 sets of parents were alive.
For that, my lord, I need to take instruction, my lord. It was all pending matter, my lord, 2008.
Please come to page 31. This is something which is readable. Page 32, we can't read, of the review petition.
Yes. Page 32 is the adoption deed, my lord. It is vernacular. Now, 31 is the, my lord, translated copy.
Yes, this is a seal of which authority at page 32? And as per this document, your mother was already dead.
My lord, yes. My father, my lord, biological father, Kalamia, he, my lord, by this letter,
No, we understand. That's why we are
Yes.
showing it to you. That's
Yes.
not the query.
yes,
Your mother is dead. That was he said. The mother is dead.
mother is dead.
So
at that
therefore,
point of
therefore
time.
you
That's why
the as a
adoption-
child,
Yes,
it was given to you. Okay, given to the second party, Samad.
Abdul Samad, correct.
Correct. That means the wife of Abdul Samad, she is not alive, perhaps, because she does not take in adoption. So a single father in a family, that's why we are asking a simple question. On these 2 dates, whether either of both set of parents were alive,
Either biological or adopted, my lord.
because biological mother has died,
Biological mother died, yes, sir, on the day of.
but the adoption is only to a male member. Now, the query is, can a Mohammedan, this is the second query, whether a Mohammedan can adopt or give in adoption singly. The mother is dead, so he can give, the biological father can give. But whether the second set, that is the adoptive parents, can he adopt singly? There's no statement whether there's no statement anywhere in this writ petition, this review petition, whether this Abdul Samad at the date of adoption had a family or not. We did not find it. And we could not read this page 32, the seal.
My lord, yes. Yes, my lord, the seal is not legible here. Yes, correct. I'll try to bring the original one, my lord, if necessary. No, कितना चल रहा है?
But with whatever I can read from page 32,
My lord.
that
लिखित
some Chaudhary, Gambura,
My lord.
correct. So some three word, is there 1, 2, 3, third word appears to be Chaudhary. Then there's the word Gambura. Gambura is not a person who is authorized to witness adoption. And this come to page 31. 31 says, this is to declare my 2-year son, namely Abdul Qadir, his mother was died, therefore I am unable to nourishing my child. Accordingly, I am willing to give son to first party for nourishment and take care of medical needs of my son. Will be take care by him. So this is not an adoption. For medical need, I may bring someone as a patient. Many a times we had kept people at our home for the purpose of medical treatment. If somebody keeps someone for medical treatment, it is not adoption, it is foster care.
My lord, the vernacular, if we read the vernacular, my lord, I am trying.
Then I can't read anything of it. Please read if you can.
My lord, let me try, my lord.
Mhm.
যিহেতুকে মোৰ কণমানিৰ 2 বছৰীয়া ল'ৰা আব্দুল কাদিৰ মাকৰ মৃত্যু হোৱাত ল'ৰাৰ নোহোৱাই দিয়া মোৰ পঢ়াত অসম্ভৱ হৈ পৰিছে, সেয়েহে উপৰোক্ত বৰাবৰৰ ল'ৰাৰ ভৰণ পোষণ
আৰু চিকিৎসা
আৰু চিকিৎসাৰ যাৱতীয় দায়িত্ব ল'ব বুলি সাক্ষ্যখনৰ সাক্ষাতত স্বীকাৰ কৰাত ল'ৰাটোৰ তেখেতৰ বিনা দাবীত সমজাই দি উক্ত শপতনামাত সুস্থ প্ৰজ্ঞানে সাক্ষীজনৰ সন্মুখত চহী কৰি শপতনামাত সম্পাদন কৰিব।
So this is not even a Hapatnama. The format is not a Hapatnama. Hapatnama is something which is we understand as affidavit. But an affidavit is not there. These are mere declarations. So nothing, not a good ground for review. Even if he meant adoption, it has not been written like this. Maximum some kind of foster care. Not an affidavit, just a declaration. please come to this order of the learned single judge, starts at page 17 of your review petition. Ms. Verma, you'll have to see this and tell us what would be the impact. Page 17 is the learned single judge. Oh, you don't have a copy. Give it to her. Give a copy to her.
It's 17 Lordship.
Page 17 is the order of the learned single judge. Yes, single judge.
My lord, this is decision.
Now turn over to page 22. Now, here the paragraph 12, the court finds discrepancy in the age. You can omit this for the time being. Now 13. Now coming to the writ code, the petitioner has projected altogether a different case to show that actually the name of his father is Kalamia and not Abdul Samad. Same was the plea in the review application. That means review application was filed before the tribunal. This was considered by this court, and then it was said that owing to the jurisdiction under certiorari, the scope, and therefore it was dismissed. Therefore, it can't be said that this issue of the name discrepancy was raised for the first time in this review application. It was already considered earlier. So if that be so, you have to tell us whether this could be a ground for review. Again, page 6 is the ground of review, paragraph 2b. The fundamental error occurred in appreciation of petitioner's paternity. The petitioner is a biological son. This plea was already raised in the review, taken into consideration, and then not accepted.
A review has been filed now.
Now, my lord, the fact of the matter that he was adopted, my lord, by the,
We have shown you paragraph 12, 13. That's why we took the trouble of reading it.
my lord, my lord.
We found it
Then, Then, my
very
lord,
absurd that there could be a adoption and their review after 11 years. We deemed it appropriate to just scan this review application by a fast reading, selective reading.
but adopted as a foster son by his cousin uncle, late Abdul Samad, in the year
No.
1962.
No. Come to page 27. This is the division bench order. In division bench order, no step was taken in the applicant at any point of time to amend the petition, the written statement to the effect that Abdul Samad was not his father but his father-in-law. The father becomes father-in-law.
Yes, my lord, after adoption,
You marry your own sister. That
Well,
can't happen.
my lord, that is permissible with all respect, my lord, in Mohammedan law. my lord.
When adoption itself is not permissible, question of marrying the own sister, she would be the what do you call, it can't be step to a stepsister. Adoption means you step into the family. You can't marry your own sister, even in Mohammedan law.
Step sister or cousin, my lord, cousin or.
You please choose your word and stick to one.
My lord,
Whether he was your father, if he is your father, his daughter cannot be your cousin. It's illogical.
the stepdaughter. Stepdaughter, now. whether
After
it is-
adoption, a stepson. We don't know, it's a new concept to us.
Adopt- That question, my lord, of course, I asked them. They said,
No, then you see, if you ask that question, then this would be an absolutely preposterous application which you have filed. You know that he is your father-in-law.
My lord.
Now you file a review saying that he is my father. No, you see, it's very
Father-
simple in Assamese.
Father,
In Assamese, it is very simple. I have dealt with this. I have dealt with this issue in a different station. There was a big fight with the lawyer and the judicial officer. And I was there to, at that time I was practicing, I went to that court and I found that lot of commotion in the courtroom beyond us. And evidently the proceedings stopped, we went there. And the lawyer was fighting with the judicial officer for having an affidavit done. It's a court in Gauhati. The affidavit is, I've said this story earlier also. The fight was because of the fact that the magistrate refused to sign the affidavit. And the lawyer was asserting that he will have it signed by the said officer only, he will not go anywhere else. This is issue of prestige. I was a new person in that, new face in that courtroom. I asked, what is the matter? So they, both the judicial officer and the lawyer treated me as a mediator, and then they said that this is, I can't understand your English. You said that the magistrate says I won't sign it because he says that he's my son and therefore he is my son-in-law, and therefore this affidavit. He says I couldn't understand, I will not sign. I asked the lawyer in that please explain this English in Assamese. In Assamese he explained that যেহেতু এই ল'ৰাটো বৰ দীঘল ডাঙৰ কৰিলো আইনমতে মোৰে ল'ৰা. So that আইনমতে মোৰে ল'ৰা becomes in English son-in-law. So I have dealt with those issues. Father becomes father-in-law, and now the daughter, which is after adoption becomes daughter, becomes now wife. Sorry, we don't find
My lord,
at 2 o'clock we.
my lord, let the matter be listed, my lord, on the.
No, it's listed only. We are not adjourning. After
my-
spending this much of time, we are not adjourning.
My lord,
the past-
I'll satisfy your lordship's queries, my lord.
Oh,
Your lordship,
That's,
my
that,
lord, my lord,
that
your
zone of
lordship asked-
satisfaction has lapsed.
My lord, your
And-
lordship said whether they are alive, my lord, at the time of adoption, my lord.
That can't be. One of them is not there, and therefore the adoption is by a single father. But the parents who have taken it, it's taken it singly. You have not given that statement. Now you can't rectify that father becoming father-in-law and then father-in-law adopting with the consent of the family. That can't be permitted. This review was already dealt with in the learned single judge. And then you change the stand. In the writ appeal, he becomes your father-in-law. Your wife was never introduced anywhere. Don't let us spend time in this. You, because of this 4,161 days, we have to read something. That too will pass others.
Obliged.
Item 44. Heard Mr. B.K. Sen, and legal aid counsel appearing for the applicant. Also heard so-and-so and counsel for the respondents. Next para. By filing this application under section 5 of the Limitation Act, the applicant who is the petitioner in the accompanying review application unnumbered review application has prayed for condoning the delay of 4191 days beyond the period of limitation in filing the connected review application. Next para. As stated in the review in this interlocutory application that the petitioner is residing in a remote village in Nagaon district and was informed of the dismissal of the dismissal of WA number 144/2014 by judgment and order dated 16/6/2014, thereby affirming the judgment and order dated 20 February 2014 passed by this court in WBC 78 of 2009. Next para. The case of the applicant is that he has recently discovered some vital documents which could not be brought in the written statement filed before the Learned Foreigners Tribunal in FT case number FT/H/722/2007. Full stop. Accordingly, in this, it is projected that the applicant seeks to now clarify that he was adopted by late Abdus ABDUS Abdul Samad SAMAD on 5/2/1962 from his biological father, namely, Muhammad MD Kala KALA Mia MIAN, within bracket also referred as Kalu KALU Mia MIA, son of Padu FALU Mia MIA. Full stop. There is a further case of the applicant that he has discovered a school transfer certificate dated 31/12/1992 issued by the headmaster of Tarkata TARKATA Muktab 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 School, Saharan SHAHARAN, Nagaon, which reveals his date of birth as 1/10/1959. Which according to the applicant proves that he was born in Assam before the cutoff date of 25/3/1971. Next para. The learned counsel for the petitioner, for the applicant, has made his submissions in support of the prayer for condoning the delay. The said prayer is opposed by the learned standing counsel for the border and FT matters. Next para. In this case, we have the court has noticed the statement made in paragraph 2 of this application that on dismissal of the proceedings of writ appeal number 144 of 2014 by judgment and order dated 16/6/2014, the same was intimated to the applicant to stop. Therefore, the applicant has woken up 12 years too late to find out, to discover the school certificate and the document of adoption. Therefore, the exercise of due diligence is found lacking in the matter, as the applicant has accepted his declaration as a foreigner provide opinion dated 19/9/2008 passed by the learned member, foreigners tribunal, Hojai at Shankardev Nagar in case number FT/H/722/2007. First of the challenge before this court was negated by judgment and order dated 20 February 2014, passed in WBC 78/2009. Which was affirmed by the revision bench of this court by order judgment and order to the 16/6/2014, passed in WA 144/2014. Next, therefore, the applicant has failed to show that he had exercised due diligence, which is required which was required to be exercised by the applicant once he was declared to be a foreigner, wide opinion dated 19/9/2008. Next paragraph. Before parting with the records, the court would like to put on record that it is well settled that as the connected review application has not been taken up, the merit of the matter not to be gone into, but the court, but under the facts and circumstances which the court has noticed from the noticed in the record, it would be appropriate to give a background of to give a background under which the writ petition as well as the writ appeal was decided. Next paragraph. In paragraph 3 of the judgment and order dated 20 February 2014, passed in the writ petition, this court has categorically recorded that after the disposal of the reference before the learned tribunal, the applicant had filed an application before the learned foreigners tribunal, seeking review of the order of opinion dated 19/9/2008, wherein the applicant had projected that his father's name is changed from Abdus Samad, ABDUS Samad, to Muhammad Kalam Mia, MAIAN. To stop. The learned tribunal took note of the same and found no ground to warrant review of the order. And the order dated 17/12/2008, passed by the learned foreigners tribunal in the review petition, was assailed by the petitioner in by filing WBC 78/2009. Stop. Next paragraph. A totally different story was made out by the applicant in the writ appeal, in the intra-court appeal. Full stop. In paragraph 2 of the order dated 16/6/2014, passed in WA 144 of 2014, the division bench of this court had recorded the following, among others, the following. Inverted commas, page 26. Red pencil. Page 27. Next paragraph. Therefore, it appears that in a departure to the review petition filed before the learned tribunal, the applicant has changed his stand that not Kalamia but Abdul Samad was his father, and in connection with the writ appeal, the stand of the applicant is that Abdul Samad was not his father but father-in-law. Next paragraph. Insofar as the claim of adoption is concerned, it would be a reiteration of the stand taken in the review petition filed before the learned tribunal. So therefore, once the matter has been agitated, again on review on the same ground, while taking a separate plea in the a contradictory plea in the writ appeal, is one aspect of the matter. Next paragraph. There is a connected legal issue involved in the said plea. Full stop. As per the position under the Muslim personal law, the traditional Muslim personal law does not recognize adoption in the same sense as Hindu law or statutory adoption. Full stop. An adopted child, merely by reason of an adoption-like arrangement under the Muslim personal law, does not acquire the same legal status as a biological child. Full stop. On the contrary, Islamic law recognizes the concept of inverted commas, kafala, K-A-F-A-L-A, inverted comma closed, under which a person may undertake the care, upbringing and financial support of a child while the child's biological lineage is maintained. So therefore, the exercise of the concept of kafala, K-A-F-A-L-A, does not ordinarily make a child an automatic legal heir of one person undertaking the care. Full stop. The court finds that the Supreme Court, the court finds that the Supreme Court of India in the case of Shabnam, S-H-A-B-N-A-M, Hashmi, H-A-S-H-M-I versus Union of India, within bracket 2014, bracket close 4 SCC 1, equivalent to AIR 2014, SC 1281, recognizes that Muslim personal law does not recognize adoption in the conventional legal sense. to stop. However, the Supreme Court of India had held that this does not prevent a Muslim from availing himself or herself of the secular statutory route to adoption, which full stop. Accordingly, the statutory of adoption mechanism is an option enabling framework available irrespective of religion. Stop. The adoption can be done under the Juvenile Justice Act, 2014. No, 2015. Juvenile Justice within bracket Care and Protection of Children Act 2015. Full stop. Therefore, the entertaining of the review application on the ground of adoption itself is contrary to the law well settled by the Supreme Court of India, as referred above. Full stop. Next para. The court again reiterates that the court has not entered into the merit of the review petition, but has only referred to the legal position of the stand of adoption taken by the sought to be raised by the applicant in the connected review petition. Next para. On merit, without entering into the merit of the review petition, the applicant, having not been able to make out a case for condoning the delay of 4-1 did 4161. 4191 days.
4191.
According to the same is the application for condoning the delay stands dismissed. Next para. As the applicant has opposed this court through a legal aid counsel, the court refrains from imposing exemplary cost. The application stands dismissed. Consequently, the unregistered interlocutory, review petition would also stand dismissed.
Right.
Time being item 43.
Deposit of 25%, you have deposited 10. My instructions are that we have deposited the amount. Main just a hearing of debt. My lord,
We remember, it is only when impolite statement is made that we have partial amnesia.
what should we take it up for hearing, madam?
Let's just see what.
Let's keep the matter. Otherwise, one affidavit is required to be filed from our end. The individual will file it. Let's keep the matter for hearing.
No, you must have clarity because of the fact that once they have deposited an amount, how much amount it is?
The amount deposited is, my lord, 6,88,467.
Okay, that is not much. We were thinking in terms of crores.
No, madam, the
Okay.
demand was around 25 lakhs
Okay,
for 2 years.
then we take it up.
Look.
How much time for affidavit?
No, within 2 weeks' time, we'll file. Let's keep opting up.
This will be filed by whom?
by the,
Deputy Commissioner,
But-
District Commissioner.
And in this, whatever documents are available with us, just give me a- in the writ appeal, you're not taking a stand separate from what has been taken in the writ petition.
in the disposition.
Correct. And in the writ petition, uh, page 103 is your affidavit in opposition by the deputy commissioner. Now, please understand that so far as the stand of the state is concerned, that is not available.
Lord.
So you better take a call.
In fact, that is what, in fact, the area has been, they said that they should not come up within that particular municipal area. And, not, I'll.
We understand, but you see, the issues are, it tangents into few more aspects.
I'll see.
As to, if you continue to maintain that township, then you'll have to say them no to do any other repair works, any other development works in the entire area. Because otherwise, if it's a township area, they will have to maintain the internal roads, electricity, the water connection, everything has to be done by the employer. So for that, we did not find any clarity.
Look, I'll see.
Even in this affidavit, I'm sorry, I only flip papers, but in that flipping process, we missed out anything where we have exonerated them from from their otherwise from looking after the township area. Because you cannot compel them to do the work and then also say that you pay taxes on that.
In fact, not too much. I'll see, because the entire idea originates that the developmental function they will do. That is why
You cannot.
I'll see.
You see, if it is your property, can I just go and say that, okay, I want 1 floor more, I will do it. You have a garden in your house, I said that no, in the name of development, I need concrete slabs to be put in. I dislike, as a chairman of the town committee, I dislike gardens. I want to put a concrete slab.
No, I'll see, because the issue is as well as the common amenities and all round development of
That
the
is,
area.
your notification doesn't say that.
I'll see.
That's what we were missing. That's why we said that in your affidavit, we don't find the stand, we are editing the stand as to their scope of work.
But
If you exonerate
For
them,
the-
he'll be more happy. He will withdraw this appeal. I can assure you.
for the department, the urban and
You-
social department, housing enforcement, I'll see.
And in these cases, this is a perfect case where you can have a mediation with this authority, Brahmaputra Valley Fertilizer.
No difficult.
To sort out the scope of, before you file your affidavit, I think your officers should go there, somebody from the secretariat should go there along with the municipal body, sit down and thrash these issues out. It's a perfect case for mediation, even in a writ proceeding.
Here, one issue is that whether the extension of the jurisdiction of the board is.
That's a legal issue which can be thrashed out in a writ petition. But if they are satisfied with the modalities, maybe perhaps they would not like to litigate further. Mediation, sending for mediation does
That
not
is-
mean that you will have to arrive at a solution.
That is.
It
one
can
part.
fail.
That is one part.
So you ask your authorities if they are
Let me-
interested.
Not,
No difficult.
You also ask
No
whether mediation to understand the scope of your
Yes, yes.
liabilities. If that can be thrashed out.
I think my clients will be ready, madam, more than willing.
I'll see.
You see, this answer is very simple. What is the threshold of expenditure in the CSR?
CSR is 3%, I think, madam.
And when they do the development work, the expenditure is more. It's a simple economics. Okay, you said, understand data, let us say council assisted by council and council for the, for the appellant applicant. Next, for Mr. D. Nath, Leonard, senior government advocate. Praise following is granted. How much time?
Well, I pray for 2 weeks' time.
2 weeks time to
Lot-
file affidavit in the matter.
Ma-
Next para.
It is second week of September.
Huh?
It is in the month of second week of September or third week.
Okay, next para. Both the issue arising in this intra-court appeal relates to the declaration of the area, earlier maintained by the Namrup area of town, Namrup Township, which was hitherto maintained by the appellant oblique applicant, was declared as a municipal area. Full stop. Under such circumstances, apart from the issues, the legal issues which arise for consideration, both sides will consider if the issues raised by the applicant oblique appellant oblique applicant can be attempt whether an attempt can be made by both sides to mediate the dispute raised in this in the connected in this intra-court appeal as well as the interlocutory application. To stop on the next date of listing, both sides shall apprise the court as to whether the parties are interested for a mediation for an out of court settlement of the issues. Next para, both the learned senior counsel for the appellant, oblique applicant, and the learned senior government advocate may send a download copy of this order to the concerned authorities to take a decision. List on solicitude. After 2 weeks, you did. Mr. Nath, it's a very simple, but I'm repeating at the cost of repetition. You see, nobody would like to make an expenditure and then pay taxes for it. If he maintains, he upgrades the status of the area, and then you say you pay higher tax.
Popo, their work.
We don't know, you try to explain it to them.
I'll.
For the development work, you want tax, and then you are burdening the appellant for the development and then lay tax on him.
I'll talk to them.
Upgrade item 45 for orders.
Well, the state has preferred a reviewed application against the order dated 20th of June 2025, passed in writ appeal 141 of 2020, and while filing that review, there is delay of 68 days. The IA is for condonation of delay of 68 days, not Lordship. But I'll just give the date, maybe on 31st of August. I'll just provide it. Check on.
Okay, heard Mr. D. Nath, the senior government advocate, appearing for the applicant, state. Next, by filing this interrogatory application, the applicants seeking review of the judgment and order dated 2025, passed by the school WA 141 of the 2020. Next. The contribution of delay of how many days? 68 days.
68 days.
68 days beyond the period of limitation in filing the connected review application. Next, issue notice returnable on so and so. Perhaps it's 31/8 and give the date.
I'll just confirm.
The applicant shall take steps within by 18/8/2026 for service of notice on the respondents by speed post with respondent by speed post with AD. In addition, the applicants shall also serve notice of this application and provide a copy of the connected memo of appeal to the respondent by dusty mode by routing the process to the registry of the court, and upon service an affidavit of service shall be filed prior to the next date of listing. Next list on Spencer. Dusty as well as this.
Lot. I'll do that.
So not just communicate that date to the court master.
I'll just
Time being item 7.
Yes. Yes.
In plain order, my lord, that is, you must can see. Annexure 2, page 17, 23. First of all, in this case, my lord, I received notice, I filed new statement, therefore, my lord, nothing from my side. So, my lord, in plain order, in National Calendar, page 17 to 23, and 17, my lord, may review 17. Uh, 18 is the judgment and order. I have gone through the materials on record.
So that we have read, you just tell us the law point involved. You did not give your evidence in this case.
No, I could not give evidence, and also, not, I could not submit any documents, and those are not with me, and my advocate took some time, but the applied was rejected, and not this order is passed.
You see, 1 day, 2 days we would have understood, but it is 4 years.
Well,
4 years time, you can't say that your advocate was keeping on taking date without your
no,
knowledge.
advocate also left me sometimes, yes.
As the court, the tribunal mentioned in the page 21 that as mentioned, as per under section 9 of the Foreigners Act 1946, the burden is on the proceeding to prove by adducing evidence that he is not a foreigner, but he is a citizen of India. But the proceeding may though file his misstatement, but by not adducing evidence, proceeding has failed to discharge his burden under section 9 of the Foreigners Travelers Act. So I could not either deposit any document or without evidence. The funds may kindly be given to deposit and to deposit the court and also to produce the points, relevant the points. Hmm? There are 20 notion mechanisms. That is the only my defense here.
And what are the reasons assigned for not filing the evidence?
Only, I have deposited the 11 documents to my advocate. That 20 I have mentioned, but only he has filed his statement and no evidence, nothing, I have mentioned also in written. The petitioner said that he received a summons from the tribunal and appeared before the tribunal for his English counsel, Devashish Sinha.
Very surprisingly, since I have a very bad habit of reading documents from back, this statement is made in para 20.
Right.
Right. Look at your affidavit in paragraph 9. How you have verified that? Yes. Page 9 is your affidavit. How you have verified it? Para 20. It is. How is how it will finish this thing. Para 20 is not even support of the affidavit. You don't have it?
Well, I don't know.
I have a bad habit, can't shake it off. Page 9 is the affidavit. So para 20 is without verification. But this is not the, it does not say that the original document will be displacement.
Hmm? 29, 20, I will. With the evidence. How will you say? Magul to be close everywhere.
You have anything to supplement your submissions? Any case law you are relying on?
There is the same judgment of the Supreme Court, Your Lordship.
Savitri Day.
Savitri, there is paragraph 39. Category 3, Your Lordship.
Here actually the proceeding is not abandoned. The proceeding is.
3 does not apply. It is reduced evidence. 3 does not apply. Your case would be under 1. But we have reference to.
One is not appeared. But he appeared, once appeared.
He is left midway. So this is not also a case of left midway.
Once appeared, they cannot say appeared, not appeared. And similarly, left in midway, there is also half.
No, he appeared. All through he is appearing. It's not a case of left midway. That's why my esteemed brother said that
My
it
submission
doesn't
is
carry
that
any of the 3 categories.
my submission, Your Lordship, is this that it comes under category 3. If Your Lordship will
Okay. Heard Mr. A. Rashid, learned counsel for the petitioner. Oh, we did not hear you, Mr. Sharma. You admit this is covered by category 3?
Apart from that, Lordship, what document Lordship proceeding has filed before this honorable court, Lordship? Oh.
No, we are not on that because
Yeah,
this is
that was-
something which we should not do.
No, Lordship, it is not all the 3 categories are not covered by this case, Lordship. I have only submitted.
Heard Mr. A. Rashid, learned counsel for the petitioner and so and so for the respondents. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 30/4/2019, page 70, passed by so and so in so and so, by which the petitioner, namely so and so, is declared to be a foreigner post 25 1971 stream. Next para. The learned counsel for the petitioner has referred to the case of Savitri, Sabitri, Savitri Day versus Swasti Day and others, comma, civil appeal number N within bracket S bracket closed 2820 of 2024, decided by the Supreme Court of India on 13/7/2026, and it is submitted that the case of the petitioner falls within category 3, Roman 3, and is covered by paragraphs 39 to 44 of the said judgment. Next paragraph. Per contra, the learned standing counsel for the border and FT matters has submitted that this is not a case where the petitioner had abandoned the proceedings So accordingly, it is submitted that the case of the petitioner does not fall in any of the three categories of category 1, category 2, and category 3 of the case of Sabitri De versus alias Swasti De within bracket Supra. Next paragraph. In the present case, on a perusal of the records received from the concerned tribunal, it is noticed that upon service of notice of the proceedings, the petitioner had appeared before the learned foreigners tribunal, and he had submitted his written statement on 17/11/2015. As per the order dated 17/11/2025, the learned tribunal has recorded that the petitioner has appeared and filed a written statement with a few photocopies of documents, and the next date of the proceeding was fixed on 16/12/2015 for evidence. Full stop. On and from 16/12/2025, 2015, six, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, the matter was adjourned on 28 occasions till 9/4/2019. So it may be stated that that by order dated 6/12/2017, the prayer for adjournment was allowed by the learned tribunal, giving last chance for filing of evidence, and the next date was fixed on 17/1/2018. Be that as it may, despite this last chance, petitioner did not file his evidence on affidavit till 9/4/2019, and accordingly, the learned tribunal, having fixed the matter on 30/4/2019 for judgment, declared pronounced the opinion on 30/4/2019. Next paragraph. Therefore, this is not a case where category 3 of the judgment and order dated the judgment passed in Savitri Day alias Swasti Day has referred to as the petitioner did not leave the proceedings midway. Next paragraph. It may be mentioned that the then standing also for the border and FT matters by referring to paragraph 12 of the case of Sabitri 12. Twelve, 13, and 12, 13, 33, 32, and 33 had submitted that the Supreme Court of India had recognized that Section 9 of the Foreigners Act of 1946 places the burden on the proceedee and that the tribunal must apply its mind on the main grounds or the proof of service and the evidence placed before it and the question referred. Stop. In the said as regard, it is, it was submitted that the three-judge bench of the Supreme Court of India, in the case of Saravanan Sonwal versus Union of India and others, within bracket 2005, bracket close 5 SCC 665, had held that the had held in paragraph 26 as follows. Accordingly, it is submitted that perhaps the observation of the three-judge bench in the case of Saravanan Sonwal within bracket Supra was not referred to, was not brought to the notice of the Supreme Court of India. Full stop. It is further submitted that the petitioner, along with the written statement, had filed only few documents which were photocopies, and therefore the tribunal could not have examined the photocopies to arrive at any opinion. So accordingly, the learned counsel for the standing counsel for the border and FT matters has by referring to the decision of Supreme of the case of Saravanan Sonwal within Supra. Has stated that if the learned tribunal has referred to the receipt or reference from the Superintendent of Police within bracket border, but it was not. And the said reference contains information to the effect that the petitioner could not show any document to prove his citizenship. There is no infirmity in the European opinion. Next paragraph. Be that as it may, Flipping papers, I suddenly saw something more. Come to page 42. Sorry, not 42, it is 25. You've got a relief certificate of 1953, 18653. That be so, he becomes a citizen of India by default.
What problem? Okay, not observation.
This is Hariman Paul. And please come to this uh, page 41. Yes, Sanjeev Paul has a reference to Hari Mohan Paul. This is Jamabandi of 1968-69. If you connect the relief certificate and this Jamabandi, you will be a citizen of India.
But as per his school certificate, Lordship, and after 11, his date of birth was 3/3/1968. Page 45.
No, that's okay.
On application, Lordship, Sanjeev Pal, Bhola Pal, all this alias Bhola Pal, Lordship. So, he has to prove that, Lordship, all these persons are same and one person, Lordship.
You only find your administration, no evidence and no good.
So that comes from this, these documents.
Yes.
The voters list it comes.
The documents was not reading from the code.
So his name was entered in the Jamabandi Lordship in the year of 1968 Lordship, but prior to 2011 Lordship, there is no voter list. What proceeding has relying Lordship is 2011 put on it in the name,
No,
name
that-
of Folapal.
That's one part of it, but the second part is that if he has the
Yes.
rehabilitation certificate and a Jhamandi of 68, he would be a citizen of India, he has to get an opportunity.
Page 25, you know, she has seen, one
Because a
certificate
citizen cannot be declared to be a foreigner.
issued by the central relief office. Central Zone Agartala.
Like, Sharma, what we do is that we adjourn the matter for 1 month. Mr. Rashid may take advice of Mr. PC there sitting behind. If he gets good advice, it's okay. Otherwise, after 1 month, we'll take it up for hearing. But the legal position, we are very clear.
Yes.
He does not get a benefit.
Yes.
We have checked the legal position. You don't get the benefit.
My lord.
because of 6A.
My lord. Masters.
Time being item 10.
My lord. Yes, but Gabura, 3% is examined. His elder brother and Gabura. No, Gabura examined. DW3. I love that. No, yeah. In document, he say, in document, father has a name, written as Hakibur Rahman. But in evidence, he said that his father never applied. In evidence, he clearly stated. Then, my lord, you also could not bring some documents for from the devoter terminal below. That is, my lord. Witness name not mentioned. Let's look at page 17. My lord, the evidence is well page 25. He's been appeared in the voters of 1970 along with his father. In paragraph 8, page 26. He stated his father has long written as Hakibur Rahman in the with his voter ID card.
Elder matter.
My lord. What? There is no document, but my evidence and my brother and Gabra evidence. My brother's name appeared along with my father in the Buddha in 1970. And my red brother has deposed in the court. And he stated that his Buddha ID card, his father name has a long list as Thakur Rahman. And I placed here some documents, my lord. And those documents could not be brought on record, page 44. The land document of 1958-59. Then one certificate issued by the Gauhati Panchayat, page 47. And a PAN card, page 48. Jamabandi. So there is no link at all, Lordship. In the end, no, what elder brother has deposed, there is no link between elder brother and his father also. Lordship, if we calculate the age, Lordship, during the time of deposition, no, page 25, I Asaq Ali, aged about 60 years. And so if he is 60 years in the year of 2017, Lordship, page 25, Lordship, is sometimes born in the year of 1957, and he
should get his first footing in the year of 1978. If he is the brother, his name should not be reflected in the voter list of 1970.
For the first time in 78.
Yes, but his name reflected in the voter list of 1970 lawsuit. So there is no such explanation is dear lordship why such discrepancies occur in the voter list. And if brother's evidence goes and Gaubura's evidence, lordship, it is not based on contemporaneous record, lordship. Already law has been settled in this regard, lordship, and oral testimony is not enough. Lordship, if Gaubura's evidence goes, brother's evidence goes, nothing will remain. And lordship, in written statement, lordship, in page 18 para 7, lordship, that the father and mother of the second party died after in the year 1970. If her parents died after 1970, so lordship, in this land document, lordship, whatever it may be, it is a Sita copy, lordship. His name should be, he should inherited this land, lordship, this Aisha Kali, projected brother of the proceeding, lordship. But there is no such name has been seen, lordship, in this land document. Lordship, page 44, it is Sita copy, lordship. And lordship, after 1970, lordship, 1970 to 1997, there is not a single document has been placed for lordship in this. I think, lordship, apart from this, I think, lordship, there is nothing more to submit, lordship.
My lord, sub submission. If first of lordship kindly see the reference case. First kindly see, and page 12. Then your lordship kindly see all the columns not furnished, my lord. The inquiry has been conducted by the ERO. You will also kindly see the page 14 onward. All columns are blank, nil. Kindly see. All columns are nil. Then, so far is my
my lord. And some documents I produced, new documents. And I think in records, there are some documents, I think that some voter list has been enclosed. Other documents have we have not no such documents. And Gaubara certificate is also on record. It is not in my hands. That may be look, and it is a case of remand. I have some documents I could not produce before the tribunal. Subsequently, I produced, I obtained and enclosed in the petition matter. In this regard, recently one judgment has been passed by this honorable judge court, remanding the matter. So and that night, tomorrow in our high court, person remand the matter to allow the petitioner to produce those documents before the tribunal below. On that point, the matter has been remanded. Then I will produce those, tomorrow I will produce my lord. So matter will remain back, and I give a chance that since Gao Panchayat has issued a certificate, I could not exhibit it. Yes. It also qualifies 47. And during the NRC period, that type of certificate has been issued as per guideline. The who are uneducated women. No, yes, madam. We could not. Yes. Government certificate produced. Yes, yes. But here the government name wrongly written as Hakibut, my father's name. But Gabara, his deposition, he said that I know the petitioner as well as his father. His father's name is Abdul Hakim. He specifically mentioned in his examination sheet, my lord. If you look at Gabara's evidence, then it is very clear. He specifically stated that I know the page 30, my lord. Page 30. I am working as a Gaubara of village Bagodi and Debradi. Debradi is my village, my lord. I have been working as a Gaubara since February 1996. I know the second party of this case. The father's name of the second party is Abdul Hakim. I know Abdul Hakim since childhood. The Abdul Hakim's one son and 5 daughters. Exhibit D is the certificate issued by me, Sensu. Cross. God here she has not cross, but God cross matter. I have issued the certificate where I written father name Hakibur Rahman, Hakibur Ali. His father, his brother, as he stated that my father's name has wrongly written in my voter ID card as Hakibur. So his evidence cannot be, maybe his certificate may not be help, but his evidence is helping. Because he, especially from childhood, he know the fathers of the petitioner. Yes, yes. Yes. Then, my lord, and more particularly, the name of the father of the petitioner. So far as document is concerned, 1970 document is there. In 1970 documents, my father's name and my brother's name appeared along with it. It is proved. It has been proved. But so far as the relationship is concerned, it has been proved. Then, in that respect, some judgment is there. So, proof of relationship. That they did not deny that I am not the brother of the proceeding. They did not deny it. And in this case, one judgment, Sujavali minor. My brother has expressed that I am the, yes, I am given my lord, Sujavali. I am the Sujavali, 2021, 4 JLT. Yes. SUJAB, Sujav Ali, Indian adults, 2021, 4 GLT, 664, paragraph 18, 19, 20, and 21. And this one, 14 bans of this honorable court, first this judgment, by referring to judgment of the Honorable Supreme Court, that those are 2008 for SCC 75, para 2028, 2008 for SCC 75, para 26, 27, 28, 30. Dancing another dancing, BANT, band. And another passes Niranjan Singh. And another cousin is my lord, 9. Yes, my lord. I'll give the answer.
My lord, which is, my lord, that the petitioner's son has been, lost in a rehabilitation center. My lord. So earlier also he was, kept in the center on several occasions. That he is an assistant engineer, my lord, he is a working employee, my lord. By mother. My lord, the mother filed an application before the superintendent of police. And after 6 documents, my lord, page number 59. That he was released on 2/5/2026 from the center, my lord, rehabilitation center. And then he resumed his duties, my lord, and he was discharging his duties, my lord. But now, again, he has been sent. My lord. My lord. My lord.
Yes.
Before filing, you did not read this. Here, you took, you write on this rehabilitation certificate
My lord.
for the purpose of regularizing your leave
My lord.
from 1/1/2026 to 23/3/2026 and 24/3/2026 to 12/5/2026.
My lord.
And now you are saying that you are not in the rehab, you are not wanting a rehabilitation.
My lord.
Your son does not want a rehabilitation.
My
And your son writes to regularize the leave because of rehabilitation.
Because earlier occasion, my lord, he was kept here. But
Please,
now-
when we are referring it to it, please spend some time looking into it.
My lord.
Page 28 says,
My lord.
1/1/26 to 23/3/26, 24/3 to 12/5.
My lord.
This is the period when you were suffering from some problems and you are in the rehabilitation center.
My lord. Earlier occasion,
Because if you make a false statement, then you.
no, finally that, my lord, he underwent treatment, my lord, and then he improved also. That certificate is also there. That now he joined his services, my lord, and then, my lord, he was discharging his duties, my lord. But again, my lord, that on 8/8/2026, my lord.
That statement you have not made here, that he recovered and then
But yes, my lord, that statement is there, my lord.
where?
My lord. That, my lord, if annexure 9, my lord. Annexure 9, my lord, that is at page number, my lord, 23, paragraph 23, my lord. Yes, 16, 15 and 16, my lord. Yes, 15 for a moment, my lord, paragraph 22, may I read, my lord. That he was living his normal life after his discharge on 2/5/2026. He was also attending duties regularly and discharging the same to the satisfaction of all. He submitted an application praying for regularizing his services during the period of his illegal detention in the rehabilitation center, which is also under consideration as transferred from letter dated 4/8/2026 addressed to the so-and-so. But having seen that his presence at home stands in the way of her free access to her paramour, as and when desired, respondent number 11 suddenly called on some unknown persons who came in a vehicle and forcefully picked him up again on 8/8/2026 at about so-and-so, and two petitioners from somewhere. That next parameter, that after his discharge from the rehabilitation center on 2/5/2026, respondent number 1 never complained of any assault or abuse.
Yes.
My lord. My lord. My lord. Presently, my lord, we have represented by respondent number 9, my lord. At present. Earlier, he was kept in, my lord, another rehab.
Private rehab, man. It is conducted by.
So after release of my, release from the rehab, my lord, I have undergone treatment and my lord. My lord. Age is, my lord, that earlier he was lost in the, in that rehab, my lord.
Yeah.
11 is the wife, my lord. Now, my lord, earlier he was lost in rehabilitation number, represented by my lord, person number 8. Then now it is in 9, my lord, he has been placed. And 10 is the sovereignty, my lord, sovereignty, where he was earlier lost.
One, two, three, four, 6 and 7. 5 minutes, he will be
Preparing for 5 look.
health नहीं हुआ.
Not 22, 2000. The last one is 02, 5, 2026. 25, 2026. No, no. Because earlier we not page number 59, we not it will not be. Because this is the second time. The first one, we not he was discharged on 22, 2026. Your lordship will find at page number 33. We not. Page number 33. We not. My lord. We not. My lord. Date of admission is 2/10/25. Date of discharge is 2. My lord. No, my lord. In this case, he was handed over to the police, my lord, on 4/2/2020. But he was
422.
my lord, it will be 4/2/2020, paragraph 7, my lord. But if your lordship is pleased to peruse page number 33, my lord. So on that occasion, 4/2/2020, he was not sent to rehab, my lord. He was handed over to the police. Then, my lord, so far as the my lord, rehab center is concerned, your lordship may consult page number 33. That was the first occasion he was taken to rehab. My lord.
22, 26.
And he was discharged on, from the rehabilitation center on 22/20/26. He was, the son of the petitioner was again taken into the rehabilitation center
Right.
on
On 2/3/2026
2/3/2026
and discharged on 2/5/2026.
and discharged on 2/5/2026.
2026. My lord.
So it is projected that since then, his son was totally cured. However, at the instance of the respondent number 11, who is the estranged wife of his son, the petitioner was again taken to rehabilitation center on
8/8, my lord. 8/8/2026.
2026. According to the petitioner, his son is no longer requiring any re-addiction. According to claiming illegal custody of his son to be in illegal custody, present writ petition has been filed under Article 226 of the Constitution of India, paying for issuance of a writ of mandamus for recovering the son of the petitioner with constitutional relief of payment of compensation. Next one. Next one. The learned senior government, the learned additional senior government advocate refers to the various dates which is reflected in Annexure 1 to the writ petition. Be that as it may, the nature of allegations made. The court is inclined to direct the inclined to issue notice returnable on. You make it Friday. You get 4 days time from today. Friday would be 21/8/2026. Requisite extra copies of the writ petition be served on the learned additional senior government advocate as well as the learned standing counsel for the health department in course of the day, along with a soft copy thereof, so as to enable them to urgently obtain instructions. Next, brother. As an interim measure, the court is inclined to direct the Is the statement who took your son to the rehabilitation center?
My lord, actually, later I came to know that he was in the rehabilitation center of respondent number 9.
We understand that, but who has taken, where is the statement? It's not very clear from your writ petition.
Yes, my lord, actually, my lord, paragraph 22 says, as per paragraph 22, my lord. Last part, my lord, page number 16. That initially the petitioner was not aware, but my lord, on 10/8, my lord. It was only on 10/8, my lord, that she came to know, the petitioner came to know that she has been lost in.
How you have drafted it?
Unknown persons, some unknown person.
Paragraph 33, I have stated that, my lord. It was only in the night of 10/8/2026.
There's no clarity if you are filing a habeas corpus, and the statements you have to run from page para 23 to para 33, then find out who has taken into custody. Because here, in para 22,
My lord.
you don't give the note, the time when you came to know. Now here in para 22, you say that on 8/8, your son was picked up and taken off somewhere.
My lord. And then
Now,
para
to
33,
give the
that,
date, to give the date, we have to go to paragraph 33. What is this?
my lord, because,
You know that we have taken up this petition in the court as a
my lord,
production matter.
my lord,
Why there is no clarity?
my lord. It was only on 10/8/2026 that petitioner came to know that petitioner's son.
Then we can't give a direction to the Paraswari police station if they have not picked up your son. How will you do it?
You know, in terms of the application,
Can
I have
there be-
submitted, my lord.
So can there be a private detention? Can somebody pick up someone and send it to the rehabilitation center? Can today two of you catch hold of me and take me to the rehabilitation center and they will keep me?
So, my lord, therefore, I submitted an application before the superintendent of police, my lord. So, on the police may be directed to, my lord,
Where is your representation? Let us see that.
my lord, page number 82.
Now you say here that on 8/8 police took him.
My lord.
Every time we ask you, then you say different thing. Which police took him?
Police, my lord, it will be,
And there is no statement that the rehabilitation center did not allow you to meet your son. This representation, you say that you went to New Way Home, but they told us that you were not there.
my lord,
Now you say that there is a Nisa Mukti Kendra.
my lord. Subsequently, I would come to know that.
Where is the statements to that effect? To show us, because how can we direct someone who is not taken into custody to find your son?
And that, my lord, paragraph 33, I have stated that by the time I filed the representation, I was not aware of as to where he has been lost, my lord. And it was only subsequently that, my lord, I came to know. Paragraph 33, that says, my lord, of my petition. Because the, my lord, local police station refused to receive my FIR, therefore I went to, my lord, the superintendent of police.
Mr. Sharma, we say that this respondent number 11, the petitioner, along with the certified copy would go to the Raspberry Police Station. Because this rehabilitation center, serial number 9 at page 4, is at Mirza.
Milo.
Mirza is within Raspberry Police Station.
Milo.
And therefore, if that be so, then he can be released. The mother will take care of the son. State has to do nothing. And the police will have the medical assessment done at the medical college, and then release it to the petitioner. He's an adult. If you live in time and is.
11 is the wife.
As the son of the petitioner and the assistant engineer and therefore an adult. The court is inclined to permit the petitioner projected to be his mother that on production of a certified copy of this order, before the officer in charge, Raspberry Police Station, within bracket, respondent number
Respondent number 7 members.
7. The officer in charge of Raspberry Police Station shall render all assistance to the petitioner. Go to the rehabilitation center under the name and style of Nisa Mukti Kendra, serial number 9, page 4. From a rehabilitation center having a unit of upswing, UPSWING, pick from respondent number 9. Here at Rashid Nagar from a Mirza, Kamrup, from a pin 781125. And one of the petitioner released from the said respondent number 9 center and to have it medically examined to any government hospital, public clinic, public center for assessing the medical condition of the petitioner, of the son of the petitioner, and thereafter handing over to the custody of the petitioner. Next paragraph. On recovery of the son of the petitioner, the officer in charge of Raspberry Police Station shall render status report in respect of the recovery of the son of the petitioner, she joined with us. Mark assistant engineer, climate assistant engineer, climate change said, Brahmaputra board. The additional senior government advocate for being produced before the court. Next one, just again on same day, Friday, 28. This will be saving.
Right again.
Because if this adult, if it doesn't want to be, if the mother doesn't want this one to be there, it can be released.
My lord,
Friday.
he may be given to the custody of her, of the petitioner also.
We have given that one to it.
My lord.